Welcome to the Deep Dive. We're here to break down complex topics, things like research, legal docs, expert takes, and turn them into knowledge you can actually use. Today, we're getting into something pretty fundamental in the business world: early termination of contracts. We sign these agreements hoping they'll stick, run their course to a set date. But life happens, right? Markets shift, circumstances change, sometimes things just don't work out. And contracts sometimes need to end before their time. So we've gathered some sources that define this, but more importantly, they map out the legal side, especially within the South African context. Our mission really is to get past just the definition. What we need to figure out is, when you end a deal early, are you automatically breaking the rules? Or, are you sometimes just exercising a right you already have?
That really is the crucial question, isn't it? Early termination, well, the basic definition is just that: ending a contract before its planned end date. But the real aha moment for you, the listener, is this: ending early is not always the same as breaching the contract. And understanding that difference, well, that's key. It determines everything that follows: litigation, damages, or maybe just a fee you agreed on.
Okay, that cuts right through a big assumption that walking away early automatically means trouble. So if it's not always a negative thing, what are the different ways this can happen? You mentioned 4 scenarios.
Exactly. Our sources lay out 4 main paths for ending an agreement prematurely. And you can think of them on a spectrum, really, from quite confrontational to pretty amicable. The first one, and usually the most contentious, is scenario 1: termination because of a breach of contract. This happens when one party, well, fundamentally fails to do what they promised, the material failure. And the moment that happens, the party that didn't breach gets the legal upper hand. They can cancel the agreement right then and there. And importantly, they can also go after the breaching party for damages, penalties, basically to recover what they've lost.
Right, so a breach is one-sided. Someone messes up, the other person reacts. What's the flip side of that coin?
The complete opposite is scenario 2: mutual agreement. This is often the cleanest way out. Both sides just sit down, talk it through, negotiate the terms for ending things early, and then formally agree to let each other off the hook for the rest of the contract. Legally, the big plus is you waive claims against each other, practically. It often saves the business relationship, which honestly can be worth more than forcing the contract through.
Makes sense. But what if the contract itself sort of planned for this? What if there's already something written in that allows for an early exit?
That brings us straight to scenario 3: specific termination clauses. These are sections written into the original contract specifically for this kind of situation. They spell out exactly what events or actions give one or both parties the right to terminate early. You need to look for things like required notice periods, maybe 90 days written notice, for example, or clauses tied to specific events like ongoing poor performance, or maybe even force majeure, those act of God type events that make fulfilling the contract impossible. If you follow the steps laid out in that clause precisely, you're not breaching. You're just using a right you both agreed on up front. And then finally, there's a unique mechanism tied to law, which brings us back to that specific legal context we mentioned earlier. Scenario 4: termination under the Consumer Protection Act, or CPA.
Okay, let's pause there. CPA, we've mentioned it a couple of times. Just for clarity, what is the CPA and who does it generally protect in these early termination situations?
Good question. CPA stands for the Consumer Protection Act. It's key South African legislation, really aimed at protecting consumers in all sorts of commercial deals, especially shielding them from, say, unfair or unreasonable contract terms. Now, crucially, for fixed-term agreements, think gym memberships, cell phone contracts, the CPA gives consumers a specific right. They can cancel early, they just need to give 20 business days notice. But, and this is a big but, this right isn't free. It comes with a definite condition. The consumer is subject to paying an early termination penalty. So, yes, you have the right to walk away, but not without some cost.
Got it. That's a really clear breakdown of the 4 paths. You've got the messy breach, the friendly agreement, the pre-planned clause exit, and this statutory CPA right with its penalty.
Right.
And knowing which path you're on seems absolutely critical for knowing the consequences. Now let's connect this back to something you mentioned, the legal philosophy underpinning this. The source material really highlights the sanctity of contracts. Why is that concept so emphasized in the South African legal system, and what does it mean practically for someone trying to end a contract early?
Right. This is where the legal backdrop gets really interesting. This focus on the sanctity of contracts. The Latin phrase is pacta sunt servanda, Agreements must be kept. It comes from the deep Roman Dutch law roots of the South African system. It means, maybe more so than in some other legal traditions, there's a huge emphasis on the idea that parties should actually do what they promise to do. Performance is key. So what that means in practice is that courts tend to take a pretty strict line on someone just deciding to walk away. If you breach the contract, the primary remedy the other party can often seek isn't just money, it's specific performance.
Specific performance.
Yeah.
Meaning they can ask the court to actually force you to finish the job.
Exactly. They can demand that you complete the contract as originally agreed. Now, often that's not practical, so the court might award damages instead, but the starting point is often, you promised, so you should do it.
Wow, okay. So if specific performance is the ideal, but damages are awarded instead, how does that affect the amount of damages? Does that sanctity idea make the financial hit bigger?
It absolutely can, because the damages are typically calculated to put the innocent party in the exact financial position they would have been in if the contract had been completed properly. So we're not just talking about getting a deposit back. We're talking about potential lost profits for the remainder of the contract term, the extra costs of hiring someone else to finish the job, maybe money wasted on materials or prep work. It can add up quickly. The sanctity principle basically says, if you bail without a proper contractual or legal reason, you're potentially on the hook for the full economic fallout your exit causes.
That makes the potential cost of scenario 1, the breach, seem way, way higher than the other options. It almost feels like the law is pushing people towards negotiating, like in scenario 2, or using those clauses from scenario 3 if they exist.
That's a very good way to put it, yes. And the strictness also helps explain why the CPA penalty exists in scenario 4. The Act protects the consumer, yes, but it also respects the agreement's sanctity by making sure the supplier gets reasonably compensated for losing that expected business.
Let's dig into that CPA penalty a bit more. If I'm a consumer and I use my CPA right to cancel, say, my internet contract early, what should I expect that penalty to look like? Is it a fixed percentage or?
Well, the Act says the penalty must be reasonable. What our sources show is that it's usually calculated based on the value of the remaining contract, but taking certain things into account. They look at the net amount the supplier would lose over the rest of the term. But critically, they have to subtract any costs the supplier saves because they no longer have to provide the service to you, things like materials, maybe delivery costs, operational expenses they avoid. And very importantly, the regulations also say the supplier has to consider if they can mitigate their loss. Can they easily sign up a new customer to take your place? If they can, or should reasonably be able to, the penalty has to be reduced accordingly. So while it's often capped at a reasonable level relative to what's outstanding, you're essentially paying a calculated price for the certainty of getting out legally.
Okay, that makes sense. Under the CPA, it's like paying a regulated fee for the privilege of exiting, which sounds much safer than risking potentially massive damages from a straightforward breach. That's a really useful distinction. So let's shift to practical advice. Given how serious the consequences can be, especially with that emphasis on contract sanctity, what are the absolute must-do steps for anyone even thinking about ending a contract early?
Absolutely. There are 3 key things that are just essential due diligence, really, no matter which of the 4 scenarios you think might apply to your situation. First, and this sounds obvious, but it's crucial, diligently read the contract. Like, really read it. Understand all the termination clauses. What are the notice requirements? Are there specific penalties written in? You have to know your potential risks and rights before you make any move. Don't wait until you want out to discover there was a specific trigger you could have used or a notice period you missed.
And why is that fine print so vital, beyond just finding an escape hatch?
Because it dictates the whole game. Let's say you think the other party breached the contract, scenario 1. If you try to terminate based on that, but you didn't follow the exact procedure laid out in the contract, maybe there was a clause saying you had to give them 14 days to fix the problem first, and you didn't go, then your termination attempt might be invalid. And guess what? That could actually make you the one in breach. It's a legal minefield, honestly. You need to know the rules of engagement set out in the document itself. Okay, the second critical factor, try to negotiate for mutual agreement. Always. Even if you feel you have a rock-solid case for breach against the other party. Trying to reach a settlement where both sides agree to walk away, scenario 2, should almost always be your first move. Why? Because litigation is incredibly slow, it's expensive, and it burns bridges badly. A negotiated settlement, even if it involves you paying a small exit fee, is usually far better than the cost, time, and stress of fighting over potentially huge damages in court.
That sounds very pragmatic. Aim for the quick, clean break rather than potentially winning a costly battle later.
Precisely. Preserve the relationship if you can, minimize the damage if you can't. And the third factor, given all the complexities we've discussed, the CPA details, the sanctity principle, reading the clauses correctly, is seek legal advice. Seriously, when there's significant money involved or your business reputation is on the line, trying to navigate this yourself is just risky. Is it a valid termination under a clause? Is it a breach? What are the actual damages likely to be? An attorney who knows contract law in your jurisdiction can help you understand your real position, make sure any notice you send is legally sound, and protect you from making a costly misstep.
Right. Well, because it's back in preparation, doesn't it?
Yeah.
Knowing your contract, knowing your options, whether it's the breach path, the CPA path, the mutual agreement path, that's fundamental to managing the risk involved. Okay, so just to quickly wrap up the main points from this deep dive, early contract termination isn't one single thing. It falls into 4 distinct scenarios, from a high-stakes breach to a more managed mutual agreement or using rights under the Consumer Protection Act. And we learned that the South African legal system really values the sanctity of contracts. This means just walking away without a valid reason can lead to significant financial consequences, often based on putting the other party back where they expect it to be financially.
And yes, we absolutely have to include the standard but crucial disclaimer from our sources. The information we've talked about here today is purely for informational and educational purposes. It is not legal advice. If you're actually facing a contract termination issue, you really must consult with a qualified attorney who understands the specifics of your situation and the relevant law.
Excellent point and a vital reminder. Okay, so to leave you, our listener, with a final thought to consider, we talked about that CPA penalty. It's a structured, calculated cost for getting out of a consumer contract early. Compare that to a mutual agreement, which might involve a similar payment, but potentially saves goodwill in the relationship. Now, imagine you're a bigger company dealing with, say, a smaller supplier. You need to end the contract early. How much is that long-term reputational benefit being seen as fair, maintaining that goodwill? How much is that actually worth compared to just sticking strictly to the potentially lower, but maybe more adversarial fee you might pay under a CPA-like scenario or a strict clause? That calculation, weighing reputation against the black and white cost, that's a real strategic business decision to ponder. And that's a deep dive for today. We hope this breakdown helps you approach contract terminations with a bit more clarity and confidence. We'll catch you next time.